Your time.
Thank you, my Lord.
Proceed.
My Lord, I'm saying that because the misrepresentation and the miscorrections not only affect the respondent, Mr. Masengeli, as an individual, but they also affect the executive and other branches of government. So it is not just a personal matter. It has widely but incorrect been alleged that the summons thereby issued have been either ignored or defied, reportedly as an act of arrogant disregard for this honorable court's authority and its constitutional mandate. Nothing could be further from the truth, and regrettably, it has not been possible to proffer a full explanation of the situation until now. My Lord, on each occasion when the personal attendance in court by Mr. Masengeli was required, he was disabled from doing so by pressing exigencies of duty out of Nairobi. And on each such instance, discreet attempts were made to communicate these difficulties to court without having to disclose delicate and sensitive operational detail which were of national security nature. When the orders of 26th of August 2024 were served on the first respondent on the 29th of August, Mr. Masengeli, in his capacity as the acting head of the police service, was already in Lamu on official duty.
On which date?
When the orders of 26th of August 2024 were served on the first respondent on the 29th of August, Mr. Masengeli, in his capacity as the acting head of the police service, was already in Lamu on official duty. As is now common public knowledge, that region suffers from a very tenuous security situation. Mr. Masengeli and other national security operatives had traveled to attend to urgent security concerns. Accordingly, the Director of Legal of the National Police Service, Mr. Charles Otiende, was detailed to attend court at the next mention of the matter on the 3rd of September 2024. He was to inform the court of the circumstances under which, thus far, the first respondent had been incapable or disabled from complying substantively with the habeas corpus application. However, the official was seized with information which would reply to the court's questions relating to the habeas corpus. The instructions to Mr. Otiende were issued on the understanding that, on a reasonable reading and construction of the order of 26th of August 2024, the first respondent could be represented in court by any competent officer or official. Mr. Masengeli had also been advised that the court proceedings on the 3rd of September were scheduled to be virtual and that the representative of the first respondent could attend virtually. My Lord, in a further effort to assist the court in its inquiry, the respondents filed an affidavit on the 4th of September 2024 in reply to the ones filed by the petitioners. In his affidavit, he set out an account of how the first respondent received a missing persons report and the ongoing investigation measures that it was undertaking to trace the whereabouts of the missing individuals. My Lord, when the matter was again mentioned in court on the 5th of September, Mr. Masengeli was still engaged in the security operations in the coast region. He provided an affidavit and affidavit evidence to this effect as Annexure GM2. This was the relevant police signal with OB numbers indicating the brutal murder of 4 men in Tana River County, presumably as a retaliatory attack in an ongoing clan dispute, which was spiraling out of control. As a result, the first respondent was represented in court by the aforementioned counsel, Mr. Otiende. Mr. Simon Kirui, the officer in charge of Directorate of Criminal Investigations, Kitengela, also attended, and Mr. Joseph Indeke, the investigating officer in the subject matter of the disappearance, also attended. After the court proceedings of the 5th of September, it was understood that Mr. Masengeli's personal attendance in court was required on 9th of September.
On which date? 5th?
After the 5th, yeah? The affidavit was filed on the 4th, but on the 5th it was clear that Mr. Masengeli's personal attendance in court was required on September 9th, or 9th of September. However, in the interim, the security situation had deteriorated considerably and increased in its complexity. As demonstrated by annexures to Mr. Masengeli's affidavit marked GM3. It is a police signal, complete with OB numbers, indicating an Al-Shabaab attack on one of the police stations in Wajir County, which event demanded Mr. Masengeli's, with other senior security personnel, personal attendance. My Lord, national security is the protection against internal and external threats to Kenya's territory and territorial integrity and sovereignty. It's the protection of Kenya and its people, their rights, freedom, property, peace, stability, and prosperity, and other national interests, as enshrined in Article 238-239 of the Constitution. All institutions of and in the Republic exist under the aegis of a secure sovereign millie. The primary object of any national security organ and security system, including the National Police Service, is to promote and guarantee national security in accordance with the principles mentioned in Article 238(2) of the Constitution. The fundamental nature of national security cannot therefore be overstated. But it is also equally fundamental and a fundamental constitutional principle that the national security organs are subordinate to civilian authority, Article 239(5). That is why, despite the excruciating and heavy security demand upon him at the material time, Mr. Masengeli nonetheless saw it fit that the DIG, Mr. Eliud Lagat, attends court on the 9th of September, and he attended. For the first respondent, he wasn't given audience, and it now transpires that, given the specificity of the orders issued by the court latterly, and quite understandably, Mr. Lagat could not and did not have audience before the court. When the court sentenced Mr. Masengeli on the 13th of September 2024 for contempt of court, he was still in Marsabit County coordinating security operations. Annexure 4, G4, in his affidavit, is a police signal with OB numbers indicating that an unknown number of armed militia had attacked a bus service.
Where was he?
Sorry?
Where was he at the time of the sentence?
Or this, when the court sentenced on the 13th of September, he was still in Marsabit County, my Lord, coordinating security operations. And that is evidenced by Annexure 4, G4, in his affidavit, which is a police signal. It has OB numbers, indicating that an unknown number of armed militia had attacked a bus service vehicle registration, KCX 039N, and had sprayed it with bullets with catastrophic results. My Lord, the main objective in setting out the foregoing facts in extenso is not to excuse the failure by Mr. Masengeli to attend court. It is hoped, however, my Lord, that it will demonstrate that he did not deliberately degenerate this honorable court, as has been characterized by counsel for the petitioners and others, nor do the facts show that he did not recognize the authority of this honorable court. The apology which he wishes to tender unduly tenders to this Honorable Court today is without reserve. It was clearly tendered earlier in his affidavit of 12 September 2024, and it is repeated here. In my humble submission, my Lord, I plead with this Honorable Court to take into account the extenuating circumstances narrated by Mr. Masengeli in his affidavit, my Lord, this is not just a simple instance of clash of loyalties. It is rather a case of a security official caught up in the horns of a dilemma, whilst in the midst of a serious and delicate security emergency. It is easy in such circumstances for one, perhaps without deliberate intention, but instinctively, to gravitate towards national security operations over personal tribulations. My Lord, it is on this basis that we plead with you to exercise your judicial discretion to incline towards grace. My Lord, may you temper justice with mercy in the realization that the actions of Mr. Masengeli in his case were not sheer or brazen, but of loyalty of a citizen gone weary in the course of doing his best in a bad situation to serve two pressing and seemingly equally demanding solemn duties. I further plead with you to take into account the contemner's promise to file regularly a progress report on the investigations regarding the missing persons or any update therefrom. Thank you, my Lord. Thank you for giving me audience. The last time I appeared before you, it was in a different capacity. I'm grateful you gave me that audience. Thank you, and I'm obliged.
Mr. Miller.
Yes, my Lord. I wish to inform the court that Mr. Masengeli is present and ready to take the stand to explain himself, as was directed by the court. I am praying that he be sworn in so that we can lead him through the process of complying with the court's order, my Lord.
I will go to the petitioners now. I will also give you time to address the court.
My Lord, I've listened to what the Attorney General has said. 2 points were outstanding. She said that there were discreet attempts to reach the court to explain serious matters of national security. What are these discreet attempts? What the court makes out of those statements is really difficult. But from our side, we find it extremely deplorable for the office of the Attorney General will admit that there was interference with the judge insofar as this matter is concerned. We'll leave it at that for now. Number 2, the Honorable Attorney General.
My Lord, I wish to take objection. Kindly. I wish to take objection.
What is the objection?
That is a very major accusation. May please take your seat. That is very major accusation. And he has to put on record where I said that there was effort, or where I was admitting that the judge was interfered with, as the Attorney General. And from my statements, where I admitted that there was interference with the judge.
So, Mr. Nelson, did you?
My Lord, number two, I'm old enough not to be distracted from my line of
Kindly
thought.
respond to that. It is important. You have made a very serious.
She has a written speech where she said there were discreet attempts to reach the court to explain the delicate nature.
Given a dictionary to define the word attempt.
Okay. What did you hear from the?
Just withdraw.
No, I will not withdraw. We are on live camera. They will play that clip if she says she didn't say it. But I've finished what I was saying on issue number one. Let me go to number two. You can go back to your notes. She said there were discreet attempts.
Attempts.
Yes.
Collins dictionary.
Please respect your office. It's there.
Well, I can't see it, but.
So okay, watacheza kwa Citizen jioni will hear it. So number.
I think Mr. Harvey, you know, we are. This is a court of law. The public is watching. Kindly let that. As a judge, I can say that. Well, maybe it has missed. I have missed it, but I don't think I have heard that.
Okay, the court may not have heard.
I may not have heard that.
But we heard it.
And if there were discrete attempts, then I don't know where they were being made.
It's okay, my lord.
Yeah.
Could you allow me to go to number
But
two?
let's proceed.
Yeah, I'm not apologizing, friends. We're dealing with a serious enterprise here.
Since you are reading a statement,
Yes.
is it in your statement that you are making discrete attempts to approach the court or something?
Hello.
What is it that you said so that it is
Yes.
clear for the record? Because I may not have captured each and every word.
My Lord, if they can make a copy, they can supply a copy to the court of what they have said.
Yes.
To clear this.
They are passing the notes there.
Yeah, let's find
My
out.
Lord, I said there were discrete attempts.
We have a right to respond to the speech,
Give information to the court
given.
on national security matter, and I stand by that because national security matters cannot be written and cannot be said in public. And if it is a matter of national security, all three arms of government collapse into one, and it can be.
All right. I didn't hear. I think then Mr. Avi is
She
correct.
has agreed, my lord. You know, she was reading, I was listening.
It was an attempt. It didn't.
Yeah, it was an attempt. An attempt is as serious as a committed action. So, my lord, permit me to finish. I'll be
Okay,
very
proceed.
short.
Yeah, proceed.
Yes. So the second fundamental issue I picked from her written speech, which she read, the submission, sorry, was that the heavy matters of national security demanded the presence of Mr. Gilbert Masengeli there, as opposed to what was otherwise personal tribulations that he was to meet in court. And my lord, this background is important. It is important for this reason. My lord, very early in the morning, we heard of reports published by none other than the President of the Law Society of Kenya, Madam Faith Moni Odhiambo, that the three petitioners had been released and dumped somewhere in Gashia. There is a background to it, my lord. Just be patient.
They have been released. No, I'm from court. I'm not being able to see what is happening.
Yes.
What are you saying?
If you could just be patient, you'll get to hear what I'm saying. So, my lord, it was our expectation today that the respondents will come and say, and we still expect them to say, that the first order for habeas corpus has been complied by us, and here before the court are the three. Relax. And if at all they have complied with the habeas corpus and produced the three, then this litigation will come to a natural end. So we'll be happy if we'll be told that that is the case, because we've just seen these reports. Number two, my lord, on the substance. Subsequent to the conviction and the sentence, Mr. Gilbert Masengeli approached the Court of Appeal on two civil applications.
Approach the Court of Appeal?
Yes, on two, sorry, not civil, on two criminal applications. One is Nairobi criminal application number E466 of 2004. 466. My lord, if you could kindly ask them to be quiet, because I need to make these submissions in quietness.
Yes, let's maintain silence.
Yeah, it's not parliament or a public rally.
Yes, proceed.
Yeah, the first is criminal application number E466 of 2024. This criminal application seeks, in the main, to stay the order convicting Gilbert Masengeli of contempt of court. Number two, before the Court of Appeal, is criminal application number E471 of 2024. In this second criminal application, Gilbert Masengeli and the rest of the team have sought an order before the Court of Appeal to suspend and stay the sentence made by this court upon conviction. My lord, indeed, these two applications were before the Court of Appeal yesterday. And they have been, yesterday? The Court of Appeal on Wednesday, the day before yesterday. And they have now been rescheduled for hearing next week, on a date that will be given by the President of the Court of Appeal. So, my lord, the derivative from the developments at the Court of Appeal are this: that the Court of Appeal is now seized of the twin question of the conviction of Gilbert Masengeli and the sentencing of Gilbert Masengeli. And for that reason, Lord, the jurisdiction that this court had can only await the Court of Appeal's decision on those two applications. Further, my Lord, those developments before the Court of Appeal have an impact on the suspended nature of the sentence this court meted on Gilbert Masengeli. The nature of that suspended sentence is therefore before the Court of Appeal. So, my Lord, with those circumstances, this court can only do two things. One is to hear from Gilbert Masengeli on how he has complied with the order for habeas corpus, because he's here. And if he has complied, as we have read, then of necessity, these proceedings must terminate. Or if they don't terminate, then they must be held in abeyance, awaiting the outcome of the challenge against your order for conviction and the order for sentencing. That, my Lord, in my humble submission, is what should happen today. I don't know whether any of my colleagues would like to speak.
No, from the petitioner side. Okay. Let's get that. A rejoinder from.
My Lord, the Vice President of the Law Society is here.
All right.
Let me put him on record first, and of necessity, he must speak. Just to say he has something, or if he doesn't have anything, then he will say as much.
Your name?
My name is Maura Kabata.
Okay, say something.
My Lord, the President Emeritus Harvey has summarized what we had to say. Just for record, I was attending the admission of advocates. That is why I did not come in good time. But as a law society, we are eager to see this matter concluded to its logical conclusion within the procedure and the framework that this court deems fit, with the nature and the weight in our petition. That is all, my Lord.
My Lord, with your kind permission, the summary of what the Law Society of Kenya is saying is that this court is functus official. It's already concluded this matter. It is pending before the Court of Appeal. And the moment it goes to Court of Appeal, the jurisdiction changes, and the matter at the Court of Appeal has to be dispensed with first before the proceedings here go. My Lord, the last one is that the issue of conduct of court has now been personalized between the judge and the convictee. And therefore, the convicted person has to comply first before they have audience of this court. They have to show that they have obeyed the court, then the court can hear them. I thank you, my Lord.
Mr. Miller.
Yes, my Lord, a brief reply. The one thing that we must take into account is the orders that this court gave on the 13th of September. The orders, my Lord, had a rider. And the rider was that Mr. Masengeli could avoid sentence if he appeared before this court within a period of 7 days. My Lord, the court defined the order as a coercive order. My Lord, this court's order is still in existence. The 7 days have not expired. We actually moved the court yesterday before the presiding judge. And we were ready to produce Mr. Masengeli even yesterday. It is the presiding judge who directed that we mention the matter before you for production, in compliance with the orders of this court of the 13th of September. My Lord, the Court of Appeal matters in question that have been referred to by my learned colleague do not have, well, first of all, were not heard on the basis of the fact that the petitioners who are respondents therein were not ready to proceed. And as a result of that, my Lord, no orders were granted by the Court of Appeal. As it is right now, my Lord, the matters in the Court of Appeal do not even have a date. To go the way the Law Society petitioner herein are suggesting to this court would be a gross violation of the first respondent's constitutional rights to a fair hearing. My Lord, you're still seized with jurisdiction as per the order you granted on the 13th of September. Your order is still alive. It has a compliance clause, and that's why Mr. Masengeli is here. And therefore, my Lord, to say that the matter is terminated is premature and a misconstruction of the order of this court of the 13th of September. Most importantly, my Lord, the petitioner's counsel, Senior Counsel Harvey, has indicated in his submissions to this court that the missing petitioners have been found. My Lord, surely the fair thing to do now would be to allow Mr. Masengeli to take the stand as you directed, to explain the circumstances as per your ruling, and most importantly, my Lord, to deny him that opportunity on the basis of the submissions of the petitioner in the face of the admission that the missing persons are alive and well would be a gross miscarriage of justice, my lord. We'd be sending him to prison for nothing. I therefore pray that you allow us to put Mr. Masengeli on the stand in keeping with your order of the 13th of September, which has not been varied, set aside or stayed by any court, so that we can comply with the orders of this court, my lord. That's all.
My lord, permit me to distinguish the application at the Court of Appeal as against the proceedings before this honorable court. It's disturbing that we appear to be approbating and reprobating the jurisdiction of this court. Is there an order injuncting these proceedings? No. Does the court have the power and authority to entertain today's proceedings? The short and straightforward answer is yes. The application at the Court of Appeal is only one. Mr. Masengeli has filed only one application and no appeal yet. That is application number E7471 of 2024. He seeks to overturn or to stay the conviction, but would be happy to be guided if these proceedings can discharge the conviction. My lord, our understanding of these proceedings and the orders are clear. This being a court of record and a court of sequence, this is the sequential order that the court directed. Number one, a sentence be and is hereby imposed of 6 months. Number two, that sentence be and is hereby suspended for a period of 7 days. On condition that the contemnor within the permitted period appears before this honorable court, which he has done, apologizes, which is why my learned senior Mr. Miller is saying that it should be sworn in so that he can adopt his statement and apologize, and then purge that contempt, in which case the court would exercise its discretion to release him ex debito justitia, having explained himself and having been pardoned, therefore free to go. My lord, the direction that commends itself at this stage is that by the presence of the contemnor hearing in court, and yesterday, what follows that, sequentially, my lord, he ought to be sworn in. Out of abundance of caution, my lord, Mr. Masengeli has filed an affidavit, which is on record, dated 20th September 2024, containing documentary and evidentiary material that he intends to rely on together with his sworn statement to improve the credibility and the cogency of his apology, we do plead and pray that the court now directs that Mr. Masengeli here is present be sworn in.
Just a minute.
Thank you.
I've not started. Just a minute. I've not made a decision. You will allow me. You have made submissions and you're already asking your client to get to the witness box.
Sorry?
Yeah, it's one of us.
Even you cannot stand to speak at the same time. Court
Now, I don't want the back and forth because if we continue like this, we will not end these proceedings.
Yes.
I thought I'd given the Law Society an opportunity to speak.
Yes, my lord.
And what Mr. Miller and Mr. Owola were doing was to respond. Was a rejoinder.
Yeah.
Isn't it?
Correct, my lord.
So why don't you then allow me to make a decision?
Yes. Yes.
Isn't that the order of things?
That's it, my lord.
They introduced some new facts.
Which one?
What facts?
That was fact that we just learned about the today.
It was not served.
Yes, it was served.
Was it served?
It was served.
Yes.
When? When was it served?
The
Yes. Let me just make a decision on this. Then.
No, just for the record, we served the affidavit. And an affidavit, we've served the affidavit.
You have admitted.
They've admitted, yeah. Okay.
But you will understand that when in a proceedings of this nature, when one is summoned before the court, you not just rely on documents, because the court will also want to observe the demeanor of that particular person.
Yes, my lord. Yes. And that's why he's here, my lord.
So it's not a question of filing documents, it's a question of complying with the order for the court to find out exactly what was happening from the person. The issue here is whether or not I should allow Mr. Masengeli to explain to the court why he has been deliberately defiant in disobeying the summons of this court.
Yes.
the record. Solicitor General has joined us.
Leading Mr. Harvey.
Yes?
Is it good?
Who?
He's come to lead Mr. Harvey.
It should be this side.
Okay. The acting inspector. So who has joined us, Mr. Abbey? Solicitor General. All right. Thank you. Welcome.
Comes immediately after the electronic here.
All right. Now this is the decision of the court. The issue before me, or before the court, is whether I should allow Mr. Masengeli, the contemner who is before the court, to explain why he deliberately disobeyed the orders of summons by the court, which led to his conviction and sentence. The Law Society of Kenya, led by the President Emeritus Nelson Havi, has urged me to deny Mr. Masengeli the opportunity. He has revealed that he has revealed to this court from the bar that the missing persons have now been released, and all I should do is to allow Mr. Masengeli to confirm that he has complied with the orders of habeas corpus so that these proceedings can come to an end. Additionally, he has argued that Mr. Masengeli has filed 2 applications before the Court of Appeal where he has appealed against a conviction and sentence, and one where he seeks an order of stay of these proceedings. Mr. Dan Manzo has argued or submitted that the court is now functus official, since the jurisdiction of this court now rests with the Court of Appeal, has now been vested with the Court of Appeal following the filing of the 2 appeals. This position has been strongly opposed by counsels for the first respondent, Mr. Miller and Mr. Ogola, who have argued that the court gave a coercive order which end compliance requirements. Further, the proceedings before the Court of Appeal are intended to deal with the conviction aspect and not the sentence. In making a decision on the issue before me, I must make reference to the sentence of the order I made on the 13th of September 2024. In sentencing for contempt, there are normally 2 ways of punishing a contemner. Actually, 2 major ways. The court can choose to adopt a purely punitive approach, or can choose to use a coercive approach in which it includes what is known as the purging conditions. The coercive approach